This video is for informational purposes. It is not legal advice. You should contact your local Citizens Advice to get help with your particular issue or problem. To find your local Citizen Advice, visit www.citizensadvice.org.uk. Hello, Adam from Citizens Advice East End here again. Welcome to the third of our videos about employment rights and the first of 3 on dismissal. Following on from our 2 videos about employment status, this is the first to really get to grips with your rights. Once you have watched our first 2 videos, you're free to watch any of the following videos about your rights in any order or as relates to your circumstances. However, whilst it will take you more time to get the clearest picture of your employment rights, you may want to watch the videos in the order set out in our introductory video. In any case, in this video, we are going to be covering the basics of dismissals. In particular, what is a dismissal, including how to spot when you have been dismissed, who is able to challenge a dismissal, that is, what employment status you need to challenge a dismissal, if you have been dismissed, the 5 lawful reasons that your employer can use to justify a dismissal, the framework for a fair dismissal process. We will not be covering this in detail as this is going to be dealt with in our second video on dismissals. And finally, we will be dealing with some straightforward points about notice periods, that's how much warning you should get before you're dismissed, and who is entitled to receive a dismissal letter. When you are dismissed, your contract is at an end. This can either be in writing, verbally, or you can reasonably infer your contract is at an end. Whatever way you think your contract has been terminated, you need to make sure that your contract is actually at an end. If something was said in the heat of the moment by you or your manager, you may want to go back and see if you can rectify the situation. On the other hand, if your boss tells you to go home and you don't hear from them for a month and don't get paid, your contract is probably at an end. However, although every dismissal is a termination of contract, not every termination of contract is a dismissal. In order to be dismissed, you must be entitled to a minimum number of hours under your contract in the first place, as if not, you will not normally be able to challenge the termination of your contract. If you are self-employed, on a 0 hours contract, or most people working through an agency, if you are no longer given shifts, that may be a basis for another type of claim, but that will not constitute a dismissal. Once you've established that you have been dismissed, you need to check that you can challenge the dismissal. Firstly, you have to check if you are an employee. So workers, that is, as stated, people who are self-employed on a 0 hours contract or are agency workers cannot challenge dismissals. How to determine employment status was covered in our first 2 videos. Secondly, you need to see how long you have been employed. Generally speaking, only employees with 2 years service can challenge dismissals. We will cover exceptions to this rule in our second video on dismissals. Thirdly, you then need to see what the reason is for your dismissal and whether or not it is actually a lawful reason to dismiss you. Finally, you need to see if you have been dismissed using an unfair process. If you are an employee with 2 years service, you can only be dismissed if it was for a fair reason and a fair process was followed. Turning to the third point on the checklist, fair reasons to dismiss, there are 5 lawful reasons to dismiss. These are conduct. This is any action you can take that can be realistically argued to relate to your behaviour at work. Capability. This is anything to do with your ability to do your job, including if you are too ill to carry on working. Legality. This is whether there is a law that stops your employer from giving you work, such as if you don't have the right to work in the UK. Redundancy. This is where your role is no longer needed within your employer's organisation. If you are told you are redundant, or you may be made redundant, this means in reality you are being dismissed for reason of redundancy. Some other substantial reason. This is occasionally used as a bit of a dustbin reason. that is, a reason employers can use if none of the other four apply. For reasons discussed in our 2 further videos on dismissals, it often comes up within the context of redundancies. Whether the process followed in a dismissal is fair will depend on the reason given for dismissal. Dismissal procedures are therefore covered in more depth in the following 2 videos on dismissals. However, for a dismissal to be fair, your employer should at the very least follow 5 basic steps. These steps, set out by the Advisory, Conciliation and Arbitration Service, or ACAS, are as follows. Firstly, that your employer needs to investigate to establish the facts. In a conduct-related dismissal, this will involve an investigation into the allegations against you. Secondly, your employer needs to tell you about the problem. If that's a capability issue, for example, that may mean arranging a meeting to discuss any issues with your performance. Thirdly, you should be informed of your right to take a work colleague or trade union representative with you. Unless you suffer a disability, or there is a separate right to take another type of representative in your contract, you are only allowed these 2 types of people. Anyone else requires your employer's permission. In addition, again, unless there is a contractual term allowing otherwise, or you have a disability, you are only allowed to take these to meetings where you are facing some sort of official punishment. Generally speaking, the right does not apply, therefore, to investigation meetings, but do apply to dismissal hearings and dismissal appeals hearings. Fourthly, your employer must decide on appropriate action. Again, this depends on the circumstances. If you are found to have committed an act of misconduct, it depends on how severe the misconduct is. Punching your boss in the face probably warrants a dismissal. Accidentally taking your co-worker's pen home probably doesn't. Finally, you should always be provided the opportunity to appeal. In addition, even if your employer does not tell you of your right to appeal, most of the time it is a good idea to send an appeal letter anyway. Appeal template letters are available from our website. Unless you are dismissed for gross misconduct, you should always receive at least the following notice. That is, advanced warning before your dismissal, depending on your length of service. For those employed between 1 month and 1 year, this is 1 week's notice. For those employed between 2 years and 12 years, this is 1 week for every complete year's service. For those who have over 12 years service, your minimum notice entitlement is capped at 12 weeks. This is just the minimum, however, and if you have a longer period in your contract, you should receive that period of notice. If you are not provided this notice, either the minimum or your contractual notice, then you should receive the same period as pay. This is often termed pay in lieu of notice, or pylon for short. Technically speaking, this should only be done if there is a clause in your contract that allows this. However, even when there isn't, if pylon is paid, you will not be able to claim for the breach of contract for not giving you notice. This is because in paying you pylon, you will not have suffered any financial loss as a result of the breach. This is what is called a technical claim and cannot be issued in the employment tribunal. In addition to notice pay, you are entitled, but only if you've been employed for 2 years, to a letter of dismissal. If you request a letter of dismissal in writing, when you are entitled to receive one, and it is not provided within 14 days, you can potentially claim an additional 2 weeks' wages compensation on top of any claim for unfair dismissal at the employment tribunal. So, once again for the takeaways, and this time we have learned, firstly, that you must be an employee to challenge a dismissal. Workers and the genuinely self-employed are not guaranteed work, so can't be dismissed. Secondly, you usually need to be employed for 2 years to challenge a dismissal as unfair. Whilst there are exceptions to this rule we are discussing in the next video, these are narrowly defined. Generally, you will find it difficult to challenge a dismissal if you don't have 2 years service. Thirdly, if you do have 2 years service, your dismissal is only fair if your employer can show that you were dismissed for a fair reason and that it followed a fair dismissal procedure in all the circumstances. Only if both of these are present will it be considered a fair dismissal, and the process to be followed will depend on the reason given. Finally, that there are only 5 fair reasons for a dismissal, and that there are 5 basic steps to follow in any dismissal process. We hope you found this video useful. The next is part 2 of our 3 videos on dismissals.